council table. With that, each side will have 15 minutes for your initial argument, and then Mr. Swanson, you'll have a 5-minute rebuttal. You can proceed with your argument.
This case is really, in my judgment, Chapter 2 of number 12091, which is the Lincoln County versus Johnson case handed down in 1977. I'd like to start with just briefly summarizing the contrasts and similarities between these two cases, then and now. Both involve government, construction, and land use projects in Lincoln County. There was a landfill then in Delapree Township, which is on the north border of Lincoln County, very near to Sioux Falls, and now it's a prison in Dayton Township, which happens to be my home township where my law office is located. So I am very privileged to appear here today to represent my neighbors in Dayton and also La Valley and other adjoining townships, all of whose land is zoned A1 agricultural district in Lincoln County. Continuing with my analysis of then and now, the city of Sioux Falls was the project proponent then, and now it's a state. Then it was Lincoln County officials who brought the action and appealed to this court. And at least here, Lincoln County is not officially present, although they did file an amicus brief. I assume the case was brought then under the provisions of SDCL 11. Assume that was the basis of the court's jurisdiction. Then the Attorney General carried the role of amicus, filing an extensive brief, which I have made part of my appendices to my opening brief. And today it's the Attorney General defending the state in this action. Back then, the Attorney General urged strongly this court to adopt the balancing of interest test, but now the Attorney General argues there is no right to be heard by the neighbors to the state's project because the state is exempt. Back then, the Attorney General argued against the city's claim of exemption. Back then, the city argued that the general rule, which was based on eminent domain powers, should exempt it from the embrace of Lincoln County zoning power. And now the Attorney General seeks to affirm the trial court's adoption of the general rule, but one that is based on possession of the eminent domain powers.
What if the difference between the two cases is that the city, in the Lincoln County case that's in our decisions, isn't the same thing as the state now, in a hierarchical way of thinking about sovereigns and units of government that are created by the sovereign?
Yes, well, the city had zoning power.
Through the state?
And through the state, as did the county, and they also participated jointly in zoning back then. That joint zoning was disrupted by the fact of the case for the for the landfill project. In this case, the state does not directly exercise any zoning power. Now, I understand the legislature has the right to direct the carrying out of the zoning power and frequently does direct, redirect, amend, and so forth on that power, both to the cities and to the county. But the state itself exercises no zoning power through its agencies or through its agents. As far as the county is concerned, it's just another governmental entity that does not determine zoning issues and is wanting to establish a land use in an area that is comprehensively planned and zoned.
Is there another critical difference between the Lincoln County case of old and the one of new, that the enforcement authority is vastly different? Whereas previously the enforcement authority was a public entity, that's not true in this case. And although you mentioned that the Lincoln County, through the state's attorney, appeared, I don't know if they ever were authorized to, but they made a motion to appear as an amicus filer and filed a brief, they're not the enforcement authority.
No, and I
clients-
recognize the clerk has sent me a letter wanting me to focus on that issue.
It was sent to both parties.
Pardon?
It was sent to both parties.
Yes, I understand.
Yeah, not necessarily a focus, but one should be prepared to address the issue.
Right. So I will try to address that now, and I'll come back to my list of then and now comparisons if I can.
Yeah, I mean, and maybe a launch point might be 11.225, for instance, which is the section of Chapter 11.2 that vests county commissions with the enforcement authority.
It does, and it indicates in Section 34 that it's the board who is to pursue injunctive relief against those who are violating the ordinance. In this case, we have the curious thing, as pled in my pleading, paragraph F4 of the complaint. However, the state agency, someone acting on behalf of the state, had already met with the county and certain members of the county board to let them know what was going to happen. That was all kept very secret from us. By the time we got knowledge of this, that relationship had already turned the county board to a neutral party and actually one who was not willing to take action for injunctive relief. We would watch news articles on local news almost daily where one or another member of the county board would get up before the cameras and talk about what a wonderful economic opportunity this prison was going to be. No talk about it makes, that it's not in compliance with the zoning ordinance. That was not the focus. We very quickly recognized, excuse me, that if there was to be anything done to challenge the state, we were going to have to do it.
Why do you say that?
County would not take action.
Do you think they had a ministerial duty to take action?
I think if it's a violation of the zoning ordinance, yes, I think they do have a duty.
Because 11.235 gives any taxpayer the authority to seek an injunction that would compel the county to enforce
True,
its
but
own.
and I'm sorry to cut you
that's
off,
okay,
but
that's okay.
what would we find at the end of that relief? We would find, cases such as Willoughby against Grimm and Jensen versus Lincoln County Board, that's a 2006 decision, where this court said mandamus is appropriate only when the duty to act is unequivocal. What would the state have said when we brought mandamus against the planning board or the county board that they had to take action. We even included the state as a party. It would trot out the very same arguments that the circuit court here found so utterly persuasive. And that is, we're exempt. There's no duty for anyone to comply with the county ordinance when you're the state.
Just
Obviously,
just the same, what's the, perhaps you're right, sort of a futility argument, I guess, but can you identify a statutory source of law that allows your clients a private right of action to enforce public zoning restrictions against anybody, and here including
no,
the state?
I'm not aware of a prior case in South Dakota that would have involved a comparable set of circumstances, because I have found that generally speaking, county boards are pretty vigilant about enforcing their comp plans and zoning ordinances. And I think in this case, Lincoln County was the clear exception. They had notice and knowledge of this case, and what did they end up doing? They ended up submitting an amicus brief which said, yeah, please decide the issue of whether balancing of interest tests are applied to the state for matters within our jurisdiction. I mean, I'm very glad they submitted the amicus
Yeah, it seems
brief.
somewhat supportive of your position.
And they are, but you know, they didn't resubmit it here. They didn't ask to be present or to make arguments in support of their position. I think we were basically cut loose and put on our own. And so if we were going to have any, as we watched the developments that were happening at this farm, at the gravel road intersections of 278th and 477th Avenue, the longer we delayed, the more certain it was that the state would be given its lead and would be allowed to go ahead and complete the project. And so within less than 30 days, we decided to take action. And so we took action under what seemed to be an applicable statute within the declaratory relief collection of statutes.
Do you believe that the Declaratory Judgment Act, which is a uniform act enacted by our legislature, do you believe that it confers any substantive rights itself?
Well, that's going to be my position, that it does, because when you've got a collection of landowners, look, the state has had this property for 35 years. They obtained it by a cheat. They've been content to have it leased and farmed by a neighboring farmer for 35 years, and then suddenly, one day, they decide it's a perfect location for a prison. All the parties that have taken action and have changed their position and have made investments in their neighboring land within the very same zoning district must surely have some right to take a neighboring landowner who has decided all of a sudden that zoning is not for them and they are privileged to be a scofflaw as to the zoning ordinance. I think those neighbors must surely have a right to challenge that position when the county itself is unwilling to do so.
So before your time runs out, Mr. Swanson, can you talk a little bit about the merits? And specifically, we've got a governmental subdivision in the county that has ordinances that says here's what our zoning is. What's their legal basis, whether it's, you know, the state has sovereign immunity, you know, preemption? What's the basis for the county to be able to apply those ordinances, those local ordinances against the state sovereign, which the county is a governmental subdivision of?
Well, I think if you look at the entirety of our zoning statutes in 11.2, I think this court said it best in footnote 4 of the Lincoln County against Johnson case, and I don't have that quote right in front of me, but I think I'm able to paraphrase it. When the court said, a review of chapter 11.2, and it also included 11.4 and 11.6 in that note, does not disclose any exemptions to the applicability of zoning regulations. When Attorney General Janklow wrote his opinion in 77-13, just a few months before that, he looked at the statutes and said this is a matter of first impression. The statutes contain no obvious exemptions that would apply for the benefit of the state. So I would start with that, I guess, as the major thrust or premise, that the zoning ordinances and the zoning statutes which authorize those ordinances are pretty clear in their face. And I think if you look at the cases that have decided to extend a general rule exemption, whether that's based on governmental immunity or sovereign immunity, or whether it's based on the power of eminent domain, it's all because there was at some point a statute which raised a question about whether the state should be included. In our case, in South Dakota, I think it's pretty clear. There are no exemptions. Not aware of one.
Any other questions?
I have one. The recent events in the legislature and the executive order,
Yes.
that's been raised now by the state. They contend, in response, they contend in essence that it has no bearing whatsoever on this case. Do you want to respond to that?
Sure. The reason I decided that these legislative events from the current session were of such importance is the fact that going into this case, first the Secretary of Corrections, the Department of Corrections, in her letter to me, which is Exhibit F3, I believe it is, to my complaint, when I questioned her about the basis of her claim for authority, quickly cited three elements. First was the Janklow opinion, then their authority under Chapter 1-15, and I forget the other, the actual subsection, their authority to maintain penitentiaries and prisons and so forth. But the third one was the fact that HB 1017 was adopted in the legislative session 2023, setting aside monetary sums and so forth and telling the secretary that she may acquire properties, and claiming that as the ultimate source of discretion to do as she wished. Of course, zoning is never mentioned in HB 1017. I thought it relevant to raise what's happened with HB 1025 in the current session and the final adoption of the executive order by the executive, wherein the location of the prison is being re-examined. So I think whatever discretion arguably existed under that HB 1017 is certainly up for reanalysis by the legislature.
Thank you, Mr. Swanson.
Thank you.
Mr. Flynn, you can proceed with your argument.